Good afternoon, everyone. I hope everyone enjoyed their lunch and you're now fueled up and ready to go for another round. I think we'd all agree that it has been a terrific discussion so far. Indeed, we've drawn from sources ranging from de Tocqueville to Jay Leno, and so let's keep it up. My name is Michael Smith, and I am the UC Hastings Symposium co-chair, and I'd like to welcome you to the Surface Water panel entitled Surface Water Systems, Managing the Future Flow. We've got quite a distinguished panel convened here, I'm happy to say, and I'm sure we're all in for another engaging and enlightening discussion. Our moderator will be Professor John Leshy of UC Hastings, and a favorite professor of mine, I might add. And my grades are also in already, so that is my sincere opinion. Although it did occur to me I did pretty well in his class, and I was wondering if he'd given me those grades because he knew I'd have the mic here, introducing him and having a chance to exact some revenge, but whatever works. Professor Leshy has been at Hastings since 2001. Previously, he was Solicitor of the U.S. Department of the Interior from 1993 to 2001, Special Counsel to Representative George Miller, Chairman of the House Resources Committee, Professor of Law at Arizona State University from 80 to 92, Associate Solicitor of the Interior for Energy and Resources from 77 to 80. He was with the NRDC in California from 72 to 77, and the Civil Rights Division of the U.S. Department of Justice in Washington, D.C. from 1969 to 72. More recently, Professor Leshy co-chaired the Obama-Biden transition team for the Interior Department in 2008-2009. He is the author of numerous books and articles on the mining law of 1872 and the Arizona Constitution. And he is a graduate of Harvard College and was a visiting professor at Harvard Law School, his alma mater, in 2004, 2006, and 2007. Please join me in welcoming Professor John Leshy.
Thank you. Thank you very much. Let me echo Alice and Rick Frank. A few words of thanks to the organizers of this conference. As they said, this is a student-run conference. It's really a remarkable thing, going back, I think, to when Tom Hicks had the brainchild of putting this together. And it's a terrific way, as you can tell already, for sort of grizzled veterans of water issues and students and aspiring entrants into the field to get together and have a really productive day. So I think it's been a wonderful conference so far. It always is, and looking forward to a good session this afternoon. We have a really outstanding panel. I'll introduce them in a minute. Rick Frank's panel right before lunch set a pretty high bar. We want to try to do the same thing in terms of fast-paced, interesting, good interaction. We'll try to match that, not have a bunch of boring conversations, but a real single conversation. What I'm going to do is I'm going to ask each panel member a question and ask them to respond to it, and then we'll open it up for the other panel members to respond or join in the conversation, and then I'll move on to the next panel member. So we're going to try to keep this lively and interactive, and we'll save time for questions from the audience. So to introduce the panel, adjectives that describe this group are, vast, deep experience, varied experience, federal, state, local, private, grizzled veterans of the water wars. If they had uniforms, they would have Purple Hearts and battle ribbons and all kinds of stuff decorating their chests. These people are really amazing in what they've done and been through. So quick introductions immediately to my right, your left. Art Baggett, most of you know all these people. I'm not going to take a long time introducing them. Distinguished and eclectic career, I think you could say, in private business, the public sector. He's been a teacher, he's been a musician, he's been a private lawyer, he's been a public official, Maricopa County Board of Supervisors, and is it finishing 2 terms or on the State Water Board? Yeah. 3 terms on the State Water Board, the attorney member, and there's probably nobody who's been more deeply involved in California water at the state and local level than Art. To his right is David Newell, longstanding associate of mine. David has a long career in public service, He was in the Cal AG's office. He was general counsel of the Air Board. He was county counsel for Santa Barbara. He worked with me and Bruce Babbitt for 8 years in the Interior Department from '93 to 2001. Then he was in private practice, and he was recently appointed, as Secretary Salazar said, his eyes and ears in California and Nevada. I think that also means that, you know, it's his back that gets beaten by people who want something out of the Department of the Interior. I'm very glad that he's back in the department. To his right, Richard Roos Collins, also somebody I've known a long time. He's kind of Mr. Hydropower. He's the Director of Legal Services at Natural Heritage Institute. He worked for EPA. He also worked for the Cal AG's office. There's nobody, I think, anybody who does anything about hydropower licensing and FERC in the country will say that Richard Roos Collins is the brain trust of that whole process from the conservation side. The Klamath water deal that you've all heard about, he had a very many hands in, important hands. It would not have happened without him. To his right, Jason Peltier. Jason's currently the Deputy General Manager, Chief Deputy General Manager of the Westlands Water District. He also has had a long career in California water, a fourth-generation Californian, many years as manager of the CVP Water Association, the sort of association of federal contractors to the Central Valley Project. He also spent 6 or 7 years in Washington, D.C. in the Department of the Interior as a Principal Deputy Assistant Secretary for Water and Science from 2001 to 2007, I think, and then came back to the Westlands Water District. And Jason, long experience. Finally, Rodollaston on the end. Many of you know him as well. He worked in the California AG's office for 36 years. Ended up several years as head of the Public Rights Division, litigated some landmark cases and then argued them in the U.S. Supreme Court, California v. U.S., the California Supreme Court's Mono Lake Public Trust decision. Then he became general counsel of the Metropolitan Water District for 2 or 3 years. Then he went back to the Department of the Interior with Jason and worked in the solicitor's office as deputy solicitor and then acting solicitor for 3 years. In the last several years, he's been in private practice doing primarily water work in California. So it's really an outstanding panel. These people know where all the bodies are buried, and I think my job is going to be in part to try to make sure we kind of collectively unearth them and in terms of going forward. Now, we heard a lot about the recent legislation, and I hope that while there will be some discussion of that, we can also talk more generally about the institutional and governance problems facing California's surface water. The next panel is groundwater. Surface water over the whole state. So not just focus on the most recent legislation. And so I'm going to start off by asking Art, as the senior member and attorney member of the State Water Board, given all that's happening as a result of the recent legislation and all the things you heard in the morning about the tremendous challenges facing California water, surface water governance particularly, is the State Board up to the task of what, of the managing the challenges ahead? And I would subdivide that into up to the task from the standpoint of their legal authority, up to the task from the standpoint of their funding base, from the standpoint of their bureaucratic machinery, and from the standpoint of the political will. The State Water Board is in the center of a lot of these issues, and so I'll pass that little hot potato on to Art.
Thank you. No, this is I guess short answer is yes, and I will try not to rope-a-dope the answers to these questions. I think given the resources, giving a more efficient procedural set of laws, and I think the big one, though, is still the political will to implement and find physical solutions to those rulings. So quickly, I think the general boards, our legal authority is incredibly broad and complex, and you're almost, I think all water lawyers, you know that. That's Article 10, Section 2 is an incredibly broad constitutional amendment or constitutional article which on waste and unreasonable use, the whole series of cases that follow from that, and the board's authority confirm our authority. We have the Public Trust Authority under Auburn and the subsequent board orders which follow, which have been challenged and upheld. I think the Racknelly and Justice Roby's recent 2006 decision, that's recent for water, I think make it real clear that water quality standards are coupled with water rights and how that process works and makes us unique. I think the ability to find physical solutions in settlements is probably the one area we may need some help with. I think in reading David's paper about the water board, I think he made a good point. For example, the Yuba took 20 years to settle that from the beginning of the first filings with our board till it was finally resolved and the court lawsuits ended. The board, while we directly can't, one of the things that frustrates me is our ex parte rules prevent a hearing officer or a board member from being involved in settlements. I think that's one authority that needs to change. That being said, I think because when we are involved, and Richard might talk at some point about the Klamath, the Orville, or even the Yuba, the Russian, some of these complex issues, I think where a policy, someone at my level is involved, it does help force a solution. That I would probably change. And I think the other legal issue is the public trust issue with evidence. And how do you get a record? Because our job as administrative body is, I've always argued, it's to get a full and complete record that we can make a decision, and that's what's going to go to court, is that record. So a partial record is really not helpful to the judicial process or to us. And I think the public trust is a challenge, getting that evidence before us. Funding, more. I mean, what can I say? We have incredibly hard and we have dedicated staff, and the furloughs have showed that to us time and time again. We've knocked out stuff that just boggles my mind, despite furloughs and Water Rights Division being way understaffed. 1968, we had 4 attorneys when Porter Cologne was passed, and roughly 90 staff in water rights. Today, 2010, after NEPA, CEQA, and all the ESA legislation, we have 4 attorneys and 84 staff. Any way you analyze this compared to any Western state, we're way behind in terms of sheer numbers of bodies and numbers of minds and folks. But we work really hard for what we were given the massive of challenge. 2008, to give you an idea, at the height of our funding, we had maybe 130 when the state was flush in water rights. We had almost 2,000 staff total in the water board, over 40 attorneys back then. The world's changed, and that's not helping. Second, I've had meetings over the years with a number of NGOs trying to put together a process to have an intervener, like PUC, every PUC in the country has an intervener statute, and they fund interveners. We don't have that, and it's very difficult. I still think without a public advocate in that record, like Tony and some of the people here were involved in the IID transfer, it was great. We had 6 NGOs with serious lawyers and some coaching, and they put on an incredible amount of evidence, which was very helpful. Normally, we don't have that. Somebody will file an intervention for the public trust and present no testimony. So it makes it difficult. It puts us in that double bind of having to do both at once. So I think that's another funding option. If we could figure out a way to fund an intervener statute. Same with a public defense almost. When we go after a little guy on some water rights issue might have incredible legal consequences for 15 acre-feet. They have no money. They don't understand water law. They'll be representing themselves, and it's a real disservice to the law that might create to not have a full complement of attorneys. Third, you talked about the bureaucracy. We have a very complex mixed system here. Anybody who's taken water law or I teach water law, it always just amazes students when they look at Colorado how simple it is, or Montana, then they look at our system, and riparians, and they start reading Miller or Lux v. Hagen and get totally confused, which is understandable. But it's a complicated system. And the bureaucracy, to make it like Colorado, we keep getting compared water courts. That won't work here. I'm absolutely convinced after 12 years. ALJs would be a major problem here. As a hearing officer, I'm doing a hearing Monday. I'll draft an order with my staff, and my colleagues give some deference to me. They know me, they deal with me all the time, they know this order wasn't done trivially, they know that how I think and listen to things, and they'll give me some deference. If there's an ALJ who's not a board member, not a peer, I think there's a real challenge. They'll just be rolled, or the board will say, well, you didn't do this, you didn't consider this, and we'll want to rehear the whole case before the board. So I think there's a real challenge with the complexity here also of water quality and water rights, because we all do water quality as well. I think the second change that would help with the bureaucracy is to have 2 attorneys on the board instead of 5, and those attorneys shall be hearing officers by law. My engineering colleagues and my public member colleague Fran would love it. They don't like to do these hearings and hear attorneys argue and motions flying. They don't mind sitting in and listening, but to run a hearing, I think that would be helpful. 2, to give a de minimis case, like 200 acre-feet, 10 CFS, where we could have a law in motion calendar like a regular court has, so we can dismiss frivolous protest instead of having to go on for 5 years. Some way where a hearing officer can say, it's a 200 acre-foot case, here's my order. If you don't like it, you can file for the full board to reconsider, but by law, it's a done order. And if the board doesn't want to reconsider it, you go to court, end of story. We could knock out 100 water right claims really quickly, because they're all little. They're small, and it wouldn't take long. They aren't, the delta should be the whole board, a big case, but small ones, I think, that would help. When I teach water law, the first thing I recommend is take family law. I mean, this stuff's, to my students, this stuff, and if you've practiced family law, I did some in my small town Mariposa practice. Anybody who's practiced that knows the favorite thing in family law is a Superior Court judge puts you both in 2 rooms and goes back and forth between the warring factions and tries to hammer a settlement. Because it goes to court, there's emotions, it's intense. Water's the same thing. And to give us the ability as a hearing officer to put parties in corners and go try to craft a settlement would be incredibly helpful and save a lot of court time and provide some settlements. Last, politics. It's political. We're kidding ourselves. Water is political. Whiskey's for drinking, right? You all know the saying. It's incredibly political. It always will be political. You never forget when Jason talks, we, the people of the United States, dried up 36 miles of the San Joaquin River. That wasn't done because Westlands did it. It was done because Congress authorized it on our behalf. It's always going to be like that. These solutions, ultimately, you've got to put a lot of it right back into the legislature. They've got to help us craft these. That being said, the big solutions, Mono Lake, that was Katz-Eisenberg passed a $96.8 million bill to put low-flow toilets in L.A. L.A. ended the case. They could have kept that in court. Tom Birmingham and crew could have gone forever. They had money, they had a physical solution, and political will. So ultimately, it's all political. In the end, I think we can have a role of forcing things like we forced Yuba, Phase 8 settlement. I think we can help force things, but in the end, I think it is politics.
Thank you, Art.
Wait. We're going to open it up to the other panel members to take a shot at Art or follow up on what he said. Anything about their experiences with the state board? Not in order, just if anybody's got any observations. Pipe up.
Well, first I've got to say, this is really intimidating. Because Tom would bring the best and the worst out of me, so I have to forewarn you that I might be a little bit insulting and irreverent, but always trying to be constructive and friendly, okay? And another just personal note is, I don't know, I have to be deferential to Art, but I don't know where he gets, when Jason talks, he didn't dry up the San Joaquin River. Where the hell did that come from?
I just figured it might come up in the discussion.
I think on the question of resources, the state board is definitely underfunded. The water rights division, it's incredible that they are limping along with the kind of responsibilities they have. That's clearly a problem, and that's a huge institutional thing that Art has to work against or with. But I would say the biggest challenge that they face is a common challenge that we face, whether it's in the Bay Delta Conservation Planning effort, whether it's in recovery planning, whether everywhere we look, trying to figure out, because we are, believe it or not, and have been in the mode ever since the CVPIA passed, trying to be in the mode of saying we recognize the route to reliable water supply runs through a healthy ecosystem. And now in BDCP, we are working really hard trying to figure out what the answer to that is. You know, how much habitat do we need? How much shaded riverine habitat? How much intertidal habitat? How much reduction of other stressors? All those things. But behind every one of those issues is this huge cloud of scientific uncertainty, and they face it on everything they deal with, and we all face it. So I think as they attempt to deal with it and separate the myth and the emotion and the religion from on one side, and then all this body of scientific, conflicting, competing scientific uncertainty, making the right decision against that backdrop is as tough for them as it is for everybody else involved with trying to move forward on water.
Okay, thank you. Anybody else? Rod?
Yeah, I just have a brief comment. One of the interesting aspects of this case is the role and the relationship between the courts and the State Water Resources Control Board in actually administering California's water rights system. I mean, so far we've heard everything about what the board does, and of course the board is the primary agency in California that regulates water rights. But historically, the courts of California have taken it upon themselves to resolve water rights issues without any real input from the State Water Resources Control Board. You go back and look at all the great decisions by the California Supreme Court, most of them simply originated in the court system and worked their way up to the California Supreme Court. About 30 years ago, in 1980, case EDF versus East Bay Mud, I stood before the Supreme Court and said, Mr. Justices of the Court, you've got it all wrong. You should require that all water disputes originate before the board, because everybody has an administrative remedy before the board. Require them to exhaust their administrative remedy and go to the board first, and then let the courts resolve these issues after the board's had a first crack at them. And the court listened politely to my argument and then rejected it in their decision. And as a result of that, the court said, in effect, the courts have original jurisdiction themselves of disputes arising under California's water rights laws, including the constitutional reasonable beneficial use requirement. About 2 years later, then the Mono Lake case came before the Supreme Court, and I had a chance to argue on behalf of the state of California in that case, and I argued that the court had it wrong before, and that at least in terms of public trust issues, the courts should require these issues to be decided first by the board, let the board resolve all these technical issues, and then let the courts look at them afterwards. And therefore, everybody should be required to exhaust their administrative remedies before the board before going to the courts. And again, the court rejected my argument. I did, I think, get 1 or 2 dissenting justices, but otherwise, the court said basically the courts have concurrent jurisdiction to resolve these issues. And so if you have a water dispute with somebody and you think somebody is wasting water or using water unreasonably, you can go directly to the courts and you don't have to go to the board. And that's the law of California according to the California Supreme Court.
Okay, thank you, Rod. Richard, do you have a comment?
I do. I agree with Art that with Art's central point, which is that the culture and tradition of water law should change in order for water to be governed more effectively. We have a culture and a tradition of war to the death, and that interferes with the ability of the board to resolve disputes because it has to resolve them. It can't rely on the parties to do so. I learned this my first day as Cal Trout's counsel in the Mono Lake cases in 1991 when I showed up in El Dorado Superior Court in a remedy trial. Adolph Moskowitz, then the lead counsel for Los Angeles Department of Water and Power, approached me with his hands out, and I thought, this is odd. And he reached to my neck, and I thought, he's going to strangle me on my first appearance? And no, he said, no, Richard, your tie isn't straight. He said, it's critically important that you have a straight tie when you appear in court. I said, thank you, Adolph. And then Tom Birmingham, who was then the junior partner representing Department of Water and Power, came up to me and he said, so this is your first day? I said, yes. And he said, you know, in water law, a case isn't serious unless it goes on for at least 20 years. And then he went on to say that his first case at Chronic, Moskowitz, Tiedemann, and Gerard was representing a client in a successor case to Miller and Lux, which dates back to, Andy, what's the date, 1870-something?
1886.
It was still going on. And so Tom looked at me and he said, you know, this is the 13th year for the Mono Lake cases. Sooner or later, these will be serious. So if I were king for the day and could fix one thing in the board, I would follow Art's lead and create a rule that effectively requires a settlement conference with real incentives or disincentives on the parties to get serious about coming forward with a proposed settlement for the board to consider.
Very good. Thank you, Richard. I don't want to leave this. We're going to go on in a second, but I do have to ask Art, and it's following up on Rod's observation. On your public trust proceeding that you're now doing in response to in the Delta, in response to the legislation, are you going to get any deference from the courts ultimately on that? What are your lawyers, or what do you
I don't think it goes to court. I mean, it's in most of the parties, all 65 notices of intent that we've had filed. I think most of them would agree. It's a workshop. It's a report. It's not rulemaking. It's made it very clear in the legislation. That was the only thing that was clear, in my opinion, in the legislation, was that it's not what it's not. What it is, we're still wrestling with, and we will be. But we will, to Jared's benefit, we will meet the deadline.
Okay, thank you.
I'm
All right, let's move on to David Nawi, and I'm tempted to say, if you sat in the morning session, Alf Brandt, I think, asked a series of questions for David to answer in this. As you all know, probably all know, the federal government is kind of a player in the California water scene to a substantial extent from various different roles. It's a sort of participant because of the federal Central Valley Water Project and other water projects, and it's running of the Lower Colorado River, and it's also a regulator through the Endangered Species Act and that sort of thing. So David has as the eyes and ears for Secretary Salazar and his backside, I suppose, when people want to take shots at it, has an awful lot to say about what the future of California water is going to be, and what kind of level of cooperation might be anticipated between the state and the federal government moving forward. So David, can you make some comments on that?
Yeah, it's very hard in a water conference to actually be able to say something positive, but on the process side, as opposed to the substantive side, I think I can be very positive about the role of the federal government, particularly in working with the state. This has obviously not always been the case. The two water projects, the State Water Project and the Central Valley Project, operate in coordination. There's, I think, a 1986 agreement called the Coordinated Operations Agreement. So they operate together as they must in terms of using shared facilities and shared storage space. But when you bring in the regulatory agencies, the history has not been that way at all. And when I mention the fish agencies, the federal fish agencies are the Fish and Wildlife Service, the National Marine Fisheries Service, which are in National Oceanic and Atmospheric Agency, which is in the Department of Commerce. Fish and Wildlife Service is in the Department of the Interior, and on the state side, the Department of Fish and Game. There's not always been good cooperation among the state and federal fish agencies. In the 1990s, Pete Wilson made a huge deal of this. He said he would not go ahead and with the State Water Board adopting water quality standards because there was so much uncertainty on how ESA requirements would play in. As a result of that, there was an increasing effort to coordinate federal agencies, something called Club Fed, which led to CalFed. And CalFed developed in the 1990s, I think a joint record of decision was signed in 2000, has really laid the basis for very solid cooperation among the state and federal agencies, and that includes the fish agencies and the two project agencies. They created a bunch of processes, and I pulled this off my machine late last night. Let me give you a few acronyms. We have the POD-PWT, the DSWG, the B2IT, the EWAT, and IEP. Let me tell you what some of those are, and then get to the most important one. The POD-PWT is the Pelagic Organism Decline Project Work Team, joint federal and state. The DSWG is the Delta Smelt Work Group. DAT, Data Assessment Team. OFF, Operations and Fish Forum. Then one near and dear to my heart in terms of what it does is IEP Science, and that's the Interagency Ecological Program, and I'll get back to that. The most important one at the top of this pyramid, or in the center of this chart, for those of you who can see it, is the Water Operations Management Team. That consists of the 3 fish agencies and the 2 project operation agencies. They meet regularly and make decisions on operations of the projects in consideration of hydrologic conditions, endangered species needs, and water quality requirements. So there really is a very great infrastructure of federal-state cooperation at the agency level. Over the years from 2000 to 2008, the federal government was much less engaged in California water than has been the case starting in calendar year 2009. In September of 2009, 6 federal agencies at the cabinet level got together, joined in an MOU, Memorandum of Understanding, and one of the primary purposes and focuses of that Memorandum of Understanding was joint collaboration, working in partnership with the state. The Memorandum of Understanding promised that there would be a federal work plan. That was issued on December 22nd, and I believe that's in your materials. Again, that work plan states that the single most important aspect of it is working together in partnership with the state and federal agencies. And that work plan also commits the state and federal governments to come out with a joint action plan focused on the next year, the last year of the Schwarzenegger administration. That should be out in the next few weeks. So we have a very solid basis of working together, and it's quite productive. Going back to science, there's a tremendous area of uncertainty on all scientific decisions involving the Bay Delta. The biological opinions are by statute based on the best available science. The best available science is far from definitive. Frequently, science does not provide certain answers, but in this case, the areas of uncertainty are vast. What we are hoping to work with the state, UC Davis, Independent Science, and the United States Geological Survey is to create a good scientific infrastructure. The state is fully on board with that process, and the independent CalFed Science program, which is going to have a new name under the new legislation, will be center in moving forward with that. There is, of course, an area where cooperation between the state and federal governments does not exist. To the contrary, the state is opposing the federal governments in the federal agencies in the litigation in Fresno in front of Judge Wanger. The water users are too. It creates a very interesting dynamic where you have people trying to work through the BDCP process collaboratively, and that is going forward in a collaborative fashion to develop long-term solutions at the same time as their lawyers focused on some of the very same issue and their paid consultants focused on the very same issues are arguing in court trying to seek what I would consider short-term advantage. Looking ahead, the legislation, which we've heard a lot about today, it's interesting. Of the 3 entities that the legislation created, we have the Conservancy, the Commission, and the Stewardship Council. 2 of those, that is the Conservancy and the Commission, both refer to federal participation, one in a liaison way and one in an advisory way. But the most important of the 3 entities, at least in my mind, I think it's pretty clear, it is the most important. The Delta Stewardship Council, there is no reference at all to federal participation in that entity and how we would participate. That being said, we do intend fully to participate and make those processes work. I've had discussions with some of the people intending to work for the Delta Stewardship Council, and we on the federal side hope to participate actively, fully, in a constructive way as the state goes forward. But because what we don't want is to come up with a situation where the state agency charged with all this power, as we've heard, comes up with something, and we on the federal side are left looking at it with either dismay, resistance, or something else. We want to continue to cooperate fully with the state, and I see no reason why that won't happen.
Thank you, David. Any other panel members have any questions about the federal government and its role? Rod?
Yeah, I spent much of my career involved in federal-state relations, and it's really wonderful to hear a federal employee talk about how much he's going to cooperate, how much the federal government will cooperate with the states. It wasn't always so. And by the way, I do have to make a comment that about the use of acronyms. I think you mentioned, David. I remember a case in the Ninth Circuit that came down a few years ago, and the Ninth Circuit went through a number of these acronyms just about like David did, and then explained them all, and then dropped a footnote that said, quote, "The use of acronyms seems to be a special province of environmental law." But again, going back to my point, 30 years ago, it wasn't like this. I mean, the federal government in the state of California just were at loggerheads over whether the federal government was required to comply with any standards, substantive or procedural, imposed by the state of California. And I remember being at conferences 30 years ago where I would present the pro-state point of view, and the federal employee, the person who sat in David's chair, said, well, no, the federal government is not subject to any requirements or limitations of California law. And the Supreme Court had actually so held in some cases in the 1950s and 1960s. And that was the federal position. And then, of course, there was litigation that eventually went to the Supreme Court, and the Supreme Court decided in 1978 that the federal government was subject to state requirements and conditions that are imposed by the State Water Resources Control Board on the Central Valley Project. And it's been that decision, plus Congress's follow-up legislation, such as the Central Valley Project Improvement Act of 1992, that kind of reaffirmed this principle. It's been those developments that have brought the federal government and the state of California together. And so when I hear about the kind of cooperation that Dave is talking about, I really welcome that, and I think that we've come a long ways in the last 30 years just because of that.
I could.
Good.
Exactly, and it's so important for another really important reason that we have a federal-state partnership, and that is the transition. As we have all these ongoing planning processes that we hope to find answers in, there's going to be a transition here with the state administration transitioning to a new administration, whole new cast of characters. Traditionally, this has kind of flopped back and forth between the federal and state administrations, and as the federal administration goes kind of dark, and then the state picks it up and kind of pass it back and forth. And I expect that to be the case starting this fall, but it'll be a performance-based reality. If the state states and feds can sign this onto this agreement in a week or so, to commit to get the BDCP, EIS, EIR done by the end of the year, and they can make some of those kind of commitments and dedicate the resources and be engaged, I think that is all very likely that there'll be a transition. Now, I need to do something that I've never done in public before, because, but you probably find it quite amusing. I hear a lot of people in the Obama administration saying, kind of dissing, you know, the Bush administration, you know, Bush ignored California water issues for so many years. And it's only interesting to me, for the most part, because I was the Secretary's designee to sit on the CalFed successor body and was the main federal face of the Bush administration dealing with California water issues. So I thought I was pretty well engaged in things, but there's a dynamic that I don't take it personally, because it is true. There was a tremendous diminution of federal focus on California water issues in the Bush administration, and there's a very simple reason why. One, Secretary Babbitt had drove to get us the CalFed record of decision. He drove everybody crazy. He drove the agencies really hard, made top priority, get it done, get it done, get it done. And they got it done in 2000. They got the CalFed record of decision. And I could just see, as we got into office, our regional directors and all the resources that had been focused on that milestone saying, oh, we got a whole bunch of other work that we haven't been paying attention to. We got to get back to that. And besides, we're moving into implementation, and that's going to be a different ball game than cutting a deal. So there was a natural thing that happened there. Plus, in the Bush administration, we saw what every administration sees. You go where the fire's the hottest, the most out of control, the most difficult, complex, biggest stakes, and we went and spent a hell of a lot more resources on the Colorado River, Columbia River, Rio Grande. Those were, and border issues, those were some places where I saw the water and science and legal resources really being invested in the bush here. So clean your act up, David.
Yeah, right.
Jason.
Rebuttal?
I give you absolute and total absolution here. You're absolved.
Oh, thank God!
Okay.
I think from my perspective, there's many of us in the room who would never accuse the Bush administration of ignoring California law, or at least those of us who knew Bennett and Jason. I would say they were fairly engaged. I think there is a difference, though, and I think in what David's bringing to the picture is we now have, well, partly we have Pete Silva, my former vice chair, is now head of the AA for water for the US EPA. Nancy Sutley's head of CEQ. And I think what David's been bringing is a more coordinated approach between EPA, Region 9, and trying to get us all, the federal team as a team. And I know that was always a challenge for some in the Interior Department before, just given the dynamics that generally take place back there. And real quickly, we had a former water division chief, Harry Schuler, some of you may know, who always had these maxims of California water. And, you know, that people would argue, the first is, when in doubt, always delay, 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 and that you're always better to be the upstream junior than the downstream senior, but then when in doubt, blame it on the Bureau.
Richard?
I'd like to underline one of the acronyms in David's presentation, which is BDCP, Bay Delta Conservation Plan. You all know that the federal and state water projects deliver water to 25 million people and sustain the agricultural economy of this state, which is second to none. Today, they operate under biological opinions, which, thank goodness, are intended to protect the listed species. But as a practical matter, those biological opinions are just about jeopardy, and they're short term, because they're under litigation and they will be changed again and again and again. BDCP is about a different future. BDCP is about a long-term habitat conservation plan and natural community conservation plan never before attempted in the Bay Delta. If we succeed at that effort and survive the litigation which is coming, then for the first time in a very long time, the state and federal systems in the Delta will be operated to achieve ecosystem recovery as well as water supply reliability. And the assurances to the water contractors will be sufficient to justify the investments and infrastructure necessary to make that happen. I bring this up because the BDCP is, for all intents and purposes, a negotiation. The steering committee consists of federal agencies in ex officio capacity, state agencies, water districts, including Westlands and others. Just yesterday, we agreed by consensus to a project description that will go forward for the purpose of NEPA and CEQA review, as well as effects analysis under the Endangered Species Act. There are many, and perhaps some in this room, who are waiting for us to fail. In fact, the BDCP, including each member of the steering committee, has already been sued in advance of our taking any final action, for our audacity to basically have the process we have. But I think this process is going to succeed, and I encourage those of you who want to, who hope for a better future in the Delta, including better cooperation between the state and the U.S., to figure out what's going on there, and if it affects your interest, to get involved in it.
Yeah, if I could, I'd like to thank Richard for the remarks and echo them. The Bay Delta Conservation Plan is of paramount importance. The federal government is working very closely with the state. As mentioned, there is going to be a change in state administrations. We don't want any momentum to be dissipated at that point. We want to keep working with the state, keep the process going. But as I mentioned earlier, there's a great difficulty in people understandably continuing to fight short-term in court with legislative proposals, letters, press releases, every other way, in a very intense conflict over what's happening now. Farmers in the Central Valley feel they don't have enough water. The species in the Delta are on the brink of extinction. These are two very strongly conflicting demands. The Bay Delta Conservation Plan, if it results in an isolated facility, conveyance, peripheral canal, call it what you will, that's not going to happen for at least 10 years. And we have 10 years to get through. And people are in intense conflict in the meanwhile. It's my hope, and it is not going to be easy, that despite that intense conflict, people will remain at the table to see the Bay Delta Conservation Plan through to a successful conclusion, because any victories in court or in the legislature are not going to solve these problems. The only way they will be solved is through an actual long-term solution based on science and that has at least some considerable degree of consensus.
Okay. Richard, you now have the floor, and why don't you just continue to talk about how you see California surface water governance going forward, particularly from the standpoint of your experience with FERC.
Okay, let me begin with a brief overview of the relationship between California and FERC, since this is a CLE conference. You can really divide the relationship into two periods, 1935 to 1994, and 1994 to the present. In 1935, Congress enacted the Federal Power Act, which said each project, hydropower project, will be best adapted to a comprehensive plan of development. Over time, the Supreme Court interpreted that to mean that FERC and only FERC makes a licensing decision. Indeed, this state lost one of those cases back in 1990. I believe, Rod, you were part of that.
That was one of my Purple Hearts.
Yes. But of course, you were vindicated in 1994 in a case called Jefferson County Public Utility District, where the Supreme Court decided that even though the Federal Power Act occupies the field, there are areas where it doesn't, and one of them is water quality, and specifically certification under Clean Water Act Section 401A. Supreme Court found in 1994 that the state has a non-preempted and exclusive authority to either issue or deny certification, and whatever's in the certification goes into the license. Since that time, I think it's fair to say, although Andy, I'd appreciate hearing your view, or Art, your view, I think it's fair to say that FERC has had to show more respect for the state of California as well as other states, because that authority means that the state has direct control over what the license says. But looking to the future, which is what John is asking me about, I really want to focus on the biggest failing of the Federal Power Act, and for that matter, the Clean Water Act Section 401A as currently administered, and offer some recommendations on how to fix it. In my view, the biggest failing is cumulative impacts. A typical license and the certification incorporated into it is required by law, including NEPA, to consider cumulative impacts, and every NEPA document says FERC considers cumulative impacts. But the functional truth is that a license and its incorporated certification is almost always about the immediate vicinity of the project. It's not about coordination with other hydropower projects. It's not about coordination with Army Corps facilities. It's not about climate change and how climate change will affect the baseline hydrology over the course of the 30 to 50 year term of a license. Indeed, I was in a conference with FERC only 2 days ago in Washington, where they said that their policy still is to not consider climate change science because it's not sufficiently reliable yet to inform a licensing decision. And so today, in a state where fundamentally we must mitigate the cumulative impacts of projects, whatever their jurisdictional stature, we are not doing that well enough in hydropower. That's the challenge we have to face. And so, in simple form, I've got a couple recommendations. Number one, the State Water Board and FERC need to complete the memorandum of understanding they are working on with respect to preparing a joint document, and they need to give special emphasis to better analysis and mitigation of cumulative impacts. And number two, the parties in these relicensing proceedings, and that means me as well as my clients and the rest of us, need to do a better job of reaching beyond the boundaries of a given proceeding and trying to achieve this kind of regional result. Oroville settlement, which Art mentioned a couple years ago, includes both jurisdictional and non-jurisdictional measures. In fact, that settlement reaches as far downstream as the confluence with the Sacramento. The fish passage measures will be implemented somewhere in the Sacramento Basin, but not in the Feather, because Oroville irretrievably blocks passage above it. It's an example of looking beyond the direct impacts to the cumulative impacts of a project